Well, they say you learn something new every day, and that's what we're going to do right now. We're going to learn a couple of things that in the next half an hour that we didn't know before about the law. Our resident lawyer, Despina Priala from boutique law firm Priala Legal in Runaway Bay, with us every Thursday. She brings her legal expertise, providing some general advice on the latest of hot topics. She has experience that spans more than 25 years in the area of property and commercial law. She also prepares wills as part of estate planning and litigation. Morning, Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning, Despina. Good morning, Wayno. So this morning, and I think it's been hitting headlines, everyone's feeling it at the moment, money is getting a little bit tight. And that means quite a few people, more maybe now than ever, are in debt, whether it's a business or personally. But Despina, you've brought this up to our attention, Creditors Statutory Demand. And this is quite a heavy demand notice that's only goes for about 21 days. So we're talking to businesses at the moment and business owners. Can you explain to us what this creditors statutory demand actually is?
I will. Yes, I do want to talk about this because it's pretty serious stuff. Okay, so anybody who has a company out there will want to listen up this morning. Anybody who is pursuing a company in a debt recovery process, right, wants to listen up. So let's put it in perspective. You talked about perhaps potentially being dire straits at the moment out there, depending on your financial position. But I thought we'd set the scene by quoting some statistics that were reported this week in the Australian Financial Review. I'm presuming they're fairly accurate. So let's put it in perspective for everybody at the moment. So there were 7,158 companies that went bust in 11 months.
Wow.
To the 31st of May, 2023. I mean, that is a substantial amount of companies that have gone bust. You've had business collapses hit the highest monthly level in more than 7 years.
Wow.
You've got uncollected, undisputed tax debt that rose from 26.5 billion from mid-2019 to 44.8 billion as of 30 June 2022. That's double. And that is horrendous. We've got the highest interest rates we've seen in unprecedented times in 12 months. We're now, I think, on the brink, or perhaps we've already got the 13th interest rate rise coming. And it's really the end of cheap money era, you know, if you can call it that. It really is. And the banks are less forgiving. The ATO has been on the warpath this year. All these terrible things that are happening. So that sort of set the scene. And then we talk about, creditors statutory demand. What is that, and do I need to know about it? And yes, you do. It's a debt recovery process for a debt that is more than $4,000. Okay, so this has been around under the Corporations Act for many, many years. It's not something new, but I think people have forgotten that this is a very real debt recovery process that does get used by companies or people that are pursuing unpaid debts. So during the pandemic, we saw a reprieve under this very process because of what was going on. And the government recognized that. So they actually temporarily changed this threshold of the 4,000 I just mentioned to 20,000, obviously recognizing what was happening in that pandemic era. But now very much we've gone back to, well, yes, it's $4,000. So if there's a debt more than 4,000 and you are a company, people can pursue you. And why are we calling it serious? Because this particular process, it's a cheaper and quicker way to get your debt paid, right, to recover it. Because what happens essentially in a nutshell is you issue a creditor statutory demand notice to that company that owes you that money. And within 21 days of you serving that notice, and we want to talk about service in a minute and how that works, you can wind up that company.
Yeah, so pretty serious stuff, yeah.
It's pretty serious stuff, and it's always been around in the Corporations Act, and I want to remind people very much so that this still exists. And the reason I want to also mention is when I talked before about service, okay, so traditionally over the course of decades, we've issued these creditor statutory demand notices by registered mail, express post, maybe courier, and where do you serve it? So typically you would serve it on a company's registered office, wherever that may be. Maybe it's their principal place of business. Maybe it's an accountancy firm. Maybe it's with a legal firm, whatever is shown on the company search. And that takes a bit of time. You do your searches, you figure out where it is, and then you end up sending it. Now, there's been a case, right, the last few months reported, which now confirms that these notices can be sent electronically.
So
Yeah.
straight away.
Mhm.
Yeah, straight
into your
away.
inbox.
You'll know your
Exactly.
debt. You
Here's
know
the
when it needs
news.
to be
Yep.
paid.
100%. So if you don't have your junk box, right, your junk
Mhm.
inbox right next to your normal inbox, you better move it to make sure that that notice isn't sitting in your junk. Yeah. And this is the other reason why I wanted to mention it today to people of this process. It's been around a long time, but the critical change is it can be sent by email. Okay. So if you've been dealing with a party for a period of time and then you haven't paid this debt that you owe, right? Or somebody is pursuing you, and you've got this email communication and address on record because you've been dealing back and forth with email. Most people do these days. So that's sufficient for that party to go, yes, well, this is your email address. I'm going to use it. I'm going to send you a notice. I'm going to serve you this notice by email because I'm allowed to now. And here's your notice. You've got 21 days from the date you send it, so that very day, for that company to deal with that notice. Now, when you get a notice like this, if you ever do, please do not put it in the bin, ignore it, or set it alight, or do whatever you think you can do for it to magically disappear. It doesn't work that way. I've said that before on the show. You've got to hit it head on.
Yep.
Okay, because if you are served with a notice like this, you do have, an ability to try and set it aside, right? And there's a couple of ways to do it. Maybe the debt that someone's pursuing you for isn't genuine. Maybe you actually are disputing that you owe this money. Happens all the time, right? So if there's a genuine dispute, then you want to go see a lawyer to try and get that set aside. Because if you don't do anything, your company will be wound up. It'll be deemed insolvent, at the end of that 21 days, and your company can be wound up. So it's pretty serious. And if that happens, you can't trade, you can't operate, your whole business shuts down.
Now, Despina, you talked about so a minimum of a $4,000 account we're talking about here. How much do you have to go through before you get to this stage? Because obviously this is a pretty serious, drastic stage. What processes do you need to go through? What sort of time are we talking about before you can get to this point?
Okay, so if someone issues you with an invoice, and there's usually trading terms in any business that you're dealing with in terms of whether you owe money or not. So whatever you get past those trading terms on your invoice or your account, 7 days, 14 days, 30 days, whatever it is, if you've tried to settle it with the party, if you're disputing it. So if they're adamant, no, you owe that money, you owe it, and that's it, and pay up. And if they've tried to issue you with a letter of demand and you just ignored it or haven't dealt with it, then yes, they can issue this Creditors Statutory Demand straight away.
So straight after, for example, a 30-day trading account. So on day 31, I mean, is that feasible, or are we talking about another month or 2 months?
No, they can. In theory, they can, and in practice, I suppose they can. But why people don't do it? Because you need a solicitor to do it. You can't do it yourself.
Yep.
Because one of the grounds to set aside a notice is if the notice itself is defective. And why would it be defective? Well, because you would do it yourself. Okay. And the statutory notice must tick all the boxes, right? For it to be 100% compliant. There's a particular form under the Corporations Act that has to be used. And obviously the wording has to be spot on, all the I's dotted, the T's crossed. So do you want to go to the expense of a lawyer who will obviously charge you to do this because it has to be accurate? So the lawyer has to spend the time to make sure, is it a genuine dispute, genuinely not paid? You've attempted, yes, let's issue it, right? So there's a costs involved. So some people don't want to do that, but some people aren't aware that it is an actual debt recovery process you can take up, which actually is cheaper than just going and issuing a claim in the court.
Oh,
okay.
there you go. So you do end up saving money.
Yes, it's a cheaper in some ways and quicker, much quicker debt recovery process. But I'd be very hesitant to advise someone to just barrel off and do this before we actually check, okay, what's the debt? It is a genuine debt. You've definitely had this person agree to it, and they definitely have not paid. So you want to check all those things first, because there are grounds for it to be set aside, you see. So you go through all that process for nothing. You wouldn't want to do that. So there is some time involved. But I think because of what's happening out there in the economy and the market, and this is across Australia. So this legislation, Corporations Act, is a federal act. It's a Commonwealth Act. So we're talking about anywhere in Australia. You want to be aware that this exists. And I think that this might even contributed to all those companies that went bust, up to the 31st of May this year. So, so just be aware that this does exist. It is out there for companies or people to use if you owe money over $4,000, and you can receive these notices by email. That's the critical thing for everyone to understand in these current times.
Yeah, definitely. Keep an eye on that junk email inbox. Great advice there. Thank you, Jasvina. And coming up next, who gets control of your estate when you die without a will? Very interesting stuff coming up in a moment.
Are you confused about legal jargon? Do you need legal advice but don't know where to turn? Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97. Despina, a leading lawyer with over 20 years of experience, will demystify the law and provide practical advice to help you navigate legal issues. Whether it's a family matter, a property dispute, or a business concern, Talking Law has got you covered. Don't miss out on this valuable resource. Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97.